My lady, my lords, I appear for the appellant, Banco Nacional De Cuba, or BNC, along with Mr. Dudnikoff and Mr. Belshaw. My learned friends, Mr. Khurshid and Mr. Pearson, appear for the respondent, CRF Ltd. With the court's permission, Mr. Dudnikoff and Mr. Pearson are sitting alongside us in the front row, as they will also be addressing the court in due course. In terms of housekeeping, we understand that Opus 2 are transcribing. They're using the live stream off-site, and they have asked, so we raise it for the court's consideration, whether the hard-working transcribers could have a 10-minute or so break every 90 minutes, if with the court's permission.
I'm afraid not.
I pass that on.
Apart from anything else, it seems to me there's a lot of material for us to digest and get through in these 2 days, and that is a large chunk of time, I'm afraid. I do appreciate that they work very hard, but it will take longer than 10 minutes inevitably, and that will break into the amount of time we've got. I'm sorry.
I pass that request on, but we, of course, are as keen as the court are to make sure that the time is used as well as we can. There's a final, by way of housekeeping, preliminary issue to deal with relating to the appellant's supplementary skeleton argument. The court will see that came in on the 26th of June, asked for, I hope the court has a copy of that.
Well, I'm afraid we only had a copy of it just a few moments ago because it didn't come in, it wasn't in the bundles, and so we've just obtained a copy of that.
Well, I do apologise to the court that that's not made its way to you. As I say, we wrote on the 26th of June, seeking permission in accordance with paragraph 32 of Practice Direction 52C. Lord Justice Males indicated that the matter, since at that time CRF rejected, which they no longer do, Mr. Khurshid informs me, Lord Justice Males sent word that the court would read the... Obviously, he's not in the Constitution, the court would read the...
Well, in any event, it wasn't in our bundles and we've only just obtained it. But let's move on from that. Have you agreed between you a timetable which fits in all the moving parts in this appeal and the respondent's notice?
My lady, yes.
Excellent.
We have. If I can outline the roadmap.
Yep.
In terms of usage of time, the parties have agreed that they should have a day each in total. So we will stop before the end of today so as to use the remainder of that time for a reply at the end of tomorrow. Ground one, running through the grounds, we will address the court on all matters that are before the court. Mr. Khurshid will then address the court on all matters that are before the court, and we will reply. In terms of the order of the grounds, since the court will have seen that there are the grounds of appeal themselves, and then there are the points, the extant points from the respondent's notice, may I outline to the court how we see that fitting together, subject to the court's consideration. This will be our proposal as to a logical order of events. Now, ground one raises an issue of Cuban law, namely whether the judge was wrong to find that consent by BNC to an assignment was not a banking operation within the meaning of the relevant provision of the BNC rules. Mr. Dudnikoff will address you on that ground. I will then address you on BNC's two further grounds, both of which raise issues of English law. So those are ratification and notice of assignment. Dealing with the respondent's notice, the court will have seen that the respondent initially raised 4 different or additional grounds on which it says that the order below should be upheld. Its point 1 raises additional arguments of Cuban law, and Mr. Dudnikoff will address those points along with the appellant's Cuban law arguments, since they're interwoven. So he will address those together when he, in a moment, addresses grounds 1. CRF's point 2 and 3 are matters of English law, which are independent of the grounds of appeal raised by the appellant. The court will see that these relate to the proposition that BNC unreasonably withheld consent to requests that CRF made in 2019 and then 2020 for consent to the assignment. Belt and braces, CRF says, in case there had been any defect in the original purported assignments. Point 2 relates to the 2019 request. Point 3 relates to the 2020 request. Now, CRF indicated in a letter dated the 12th of July that it no longer pursued point 3. So the argument that's the argument as it relates to 2020. So the focus here was entirely on the 2019 request. Finally, point 4 of the respondent's notice raises additional matters in relation to the appellant's ground 3. That's the argument about the notice of assignment and its correct delivery. So I will address those along with the appellant's ground 3. So where that leaves us, subject to the court's approval, is that firstly, Mr. Dudnikoff will address you on the Cuban law issues. I will follow on the English law issues covering both our appeal and the respondent's notice points, although of course recognising that we may have to say more in reply on those points which are being run by Mr. Khurshid. So I will follow an English law, taking ratification first, then withholding of consent, then notice of assignment. So we hope that that's a sensible division and structure, subject to the court's approval. And as I say, we've agreed with Mr. Khurshid that we will finish before the end of today and use the equivalent of that remaining part of today at the end of tomorrow by way of a reply.
Thank you very much for that outline. I think that looks a sensible way of proceeding, and please therefore deal with it in that way and cut your cloth according to the time, and that we will be rising at 4:15 on both days. Thank you.
I'm grateful. With that short introduction then, I will swap with Mr. Dudnikoff.
My lady, my lords, as Mr. MacDonald's already mentioned, the first ground of appeal relates to an issue of interpretation of Article 15L of the BNC rules, and in particular whether the judge was wrong to find that the act of BNC's consent to an assignment was not a banking operation within the meaning of that provision. The way that I would propose to address ground 1 is in 4 parts. First, the principles which we say apply to an appeal on an issue of foreign law, and I appreciate the court will be familiar with this, so I will aim to be brief. I would then propose to show the court the relevant parts of the BNC instruments, the rules and the statutes, then turn to the expert evidence that was adduced at trial, and finally go through the relevant paragraphs of Mrs. Justice Cockerill's judgment.
Well, that doesn't seem to involve telling us how Article 15L comes into the case in the first place. And speaking for myself, I would appreciate an explanation of that matter before you get into the detail.
Of course. And my lord, may I deal with the principles that we say apply before turning to that? Very well. So turning to the principles, there are 2 relevant authorities that are in the bundles that I don't propose to go to them, but it's Perry and Lopag in tab 17, Deutsche Bank in tab 16. The relevant passages are sidelined, but I will attempt to summarize the propositions that we submit are relevant to this appeal from those 2 cases. The first proposition is that findings in relation to foreign law are findings of fact, but of a special kind. And that is because, in certain circumstances, an English judge can use their legal skills and experience in the analysis of domestic law to analyse foreign law. So that's the first proposition. Proposition 2. There is a spectrum of circumstances in which the main variable is the degree to which the judge can use their skill and experience of domestic law to ascertain what the foreign law is and apply it to the case in question. That's proposition 2. Proposition 3, it is not inconsistent with the idea of a spectrum that there are cases where the appellate court considers itself able to review the findings of a trial judge on foreign law in circumstances where it is not in the family of common law systems. Much will depend on the nature of the alleged error of the trial judge and the circumstance in which the error arose. And that's Perry, paragraph 19. Proposition 4, and this may be just another way of expressing the previous point, but the relevant question is not to ask whether the foreign legal system is in the common law tradition, but to ask whether and to what extent the issue calls for the exercise of legal judgment by reference to principles and legal concepts that are familiar to an English lawyer, and when, and to the extent that it does, the appellate court is as well placed as the trial judge to form their own independent view. And that's Perry, paragraph 12, citing MCC proceedings. And the fifth proposition relates to this court's approach to an appeal against the finding of fact. So when we're one end of the spectrum. And that's not something I propose to dwell on. The court will be very familiar with the principles, but
has to be rationally insupportable. Volpe and Volpe.
Yes. And there's a lengthier summary in the judgment of Lord Justice Mayles in Deutsche Bank, paragraphs 48 to 53. In that regard, as CRF says at paragraph 13.7 of its skeleton, and we agree with this, the appropriate degree of restraint may be influenced by the nature of the conclusion and the extent to which it depended upon an advantage possessed by the judge. And I will come on to show the court the evidence that we had on Article 15L in due course. But for now, the relevant point that I note is it was brief. There was no Cuban court authority which required analysis. There was no legal commentary, no textbooks. All that the experts had before them was the text of Article 15L, which nobody suggested was ambiguous. The translation was uncontested. There was an argument about the translation of another provision, but not 15L. So the advantage possessed by the judge in this case, we say, was relatively limited. And this is not really a case where there was a vast sea of evidence, to use the expression used in the case law, on Article 15L, such that the Court of Appeal would be island hopping. Nor is it a case, I would submit, where we're looking at a legal rule or a principle that's alien to the eyes of an English lawyer. The words any other banking operation, which are the critical words in Article 15L, do not require the English court to grapple with a concept that's unfamiliar. And although, of course, we accept, and it's common ground, that Cuban law is not in the common law tradition, the nature of the errors that we allege and the circumstance in which they arose are such that I submit the court can consider itself able to review the judge's findings on Article 15L in accordance with the approach in Perry. And I will seek to make that submission good when I come to look at the evidence, or to show the court the evidence. But in any event, and regardless of where we are on the spectrum, in my submission, this is a case falling within the traditional categories on which a finding of fact can be impugned on appeal. And again, I will develop that further when we turn to the judgment. So that's all I had to say on the principles. Turning then to the B&C rules first, before turning to the statutes. Could I ask the court, please, to turn them up? It's in the first supplemental bundle, tab 4. And can I just check whether the court is working from hard copies or electronic? So in that case, I will use tab numbers as well. So tab 4, page 18.
Thank you.
And my Lord Justice Arnold's question on 15L, I haven't forgotten about it, and I am coming to it when we get to 15L in the rules. So this is the English translation that was in the trial bundles. We don't have here the Spanish original, but that was before Mrs. Justice Cockerill. The B&C rules, as the title suggests, is in the form of a resolution, number 10 of 2016, of the president of B&C. And we can see it's Mr. Fernandez at the bottom of the page, and the rules are dated 26th of April 2016. I'm not going to go through the recitals, but I simply note that they refer to the president's powers to delegate his authority to other officials. That's recital 1. They refer to the need to update the regime governing authorized signatures of officials and agents of B&C. that's recital 2, and to the President's powers to issue orders, instructions, and so on, that are binding on the bank, and that's recital 3. And then we have the operative part of the resolution referring to the annex, and that's where the rules are found over the page.
So, am I correct in understanding so far that this is a document about signatures?
In part, my lord. In part, but
Seems to flow from the title, authorisations, uses, signatures, and the second recital.
it is in part where the signature is the means by which the bank is bound, and that's section 1 of the BNC rules. Over the page, they're called sections here, elsewhere they're called articles. Section 1 says, bank powers of attorney may be conferred on certain officials and employees of the National Bank of Cuba based on their function and responsibilities through the granting of use of banking signatures so that they may act in the name and on behalf of such bank under the rules herein and thus enter into any relevant banking transaction.
All right, but maybe there's a finding of the judge on this question, but as I understand it, it's your case that these rules apply to a document that doesn't purport to be signed. Is that correct? And if so, where's the judge's finding?
Well, that's signed with a handwritten signature.
I'm talking about an email.
Yes, yes. So it is our case that the rules apply.
So even though it's an email which doesn't purport to bear a signature?
My lord, that's correct, but there's this point to note on that, which is that there was no inquiry at first instance about whether an electronic signature would have sufficed. And one can speculate as to why that was the case, but the email only has one signatory. It's only Miss Marty.
But of course it depends what you define as a signature, doesn't it? Because in the ordinary understanding, a signature is something that is manual. Now, of course, in the electronic age, we understand that in some contexts, something that is typed may be accepted as being equivalent to a signature. But that all depends upon what the relevant context is, doesn't it? And one would assume that there are some findings of the judge on all of this.
Well, there are no findings on that, as far as I can recall, on that specific point. And as I say, the reason is probably because whether an electronic signature would suffice for the purposes of the rules was not a point that was explored in evidence. Now, there are examples of emails bearing 2 electronic signatures. There are examples, and they were before the judge, and they are in the bundles, in the second supplemental bundle, and perhaps I can show an example. Second supplemental bundle, tab 3. Where we can see an email addressed to Mr. Don Stevenson, Mr. Gord Handers. And the relevant point that I would like the court to note is that at the bottom, the sign-off, it says, best regards, Londa Marty, assignment of Raul Oliveira, manager. So there are, and this is not the only example, there are others. At tab 3, apologies, at tab 2, there's another example where, again, the same 2 individuals sign a single email. Now, this is not something that was explored at trial, but the email of the 13th of June, 2019 was only signed by one person. So it's not something that arose for determination. But the judge did, and I will come on to show the court the relevant passages, the judge did consider whether the BNC rules required 2 signatures to be applied, having already found that consent had been given through Miss Marty's email. In other words, it was an essential part of her reasoning, and had she concluded that the two-signature requirement was applicable, according to the terms of the rules themselves, we say the natural conclusion would have been that it was not satisfied, because the 13th of June email bore only one signature, electronic in this case.
Let's also be clear about our terms. You took us to the second supplemental bundle, tab 3, to that email to Mr. Stevenson and Mr. Godanas. And at the bottom, that has 2 names and their respective statuses.
Yes.
But those are not signatures, those are just names.
Yes.
And so that's what we're talking about. We're talking about an email with a name or 2 names at the bottom. We're not even talking about an electronic signature.
No, that's right.
That's all we're talking about. So when you mean signature, in this case, you're meaning
a typed name.
A sign-off, put it that way.
Yes.
So let's not get too confused.
Of course. And I've said this before, but it's important to emphasise that this was not an issue at trial, whether what form the signature had to be in, or whether what we see here in the second supplemental bundle
is a signature or not.
Yes, quite.
But is it fair to say that all parties, including the judge, proceeded on the basis that typing a name on the bottom of an email was a signature?
Well, that's how we would say the judgment should be read. Yes, not explicit. Mrs. Justice Cockerill doesn't make it explicit, but that's the only way of reading it that we say is consistent with her conclusions. And the fact that she examines the B&C rules, and I will come on to develop this and look closely at the judgment. She examines whether the rules apply, having already found that the relevant act was the email. So what would be the point in that inquiry if an electronic signature was insufficient? So going back, please, to the first supplemental bundle, to the B&C rules. I read out section 1, and the point we make here is that it is through the means of their signature that an official of B&C is able to act on behalf of B&C and to cause the bank to enter into a relevant banking transaction, or banking operation, I should say. Section 1 here says banking transaction, whereas the translation refers in other parts to operation. And the Spanish original is the same term, and operation would be the more accurate translation. So that's section 1. Section 3 says any signing authority shall be granted, revoked, and amended by the President. So the President is the only person who had power to authorize an operation by signing in their sole name, because he or she was the legal representative of the bank. And the President was the source of power conferred on other officials of the bank who, unlike the President, could not sign in their sole name, but only with another signatory. And the seniority of that other signatory was determined by the value of the banking operation in question, from the most senior, A, to the most junior, C category. And I will come on to those provisions in a moment.
How does section 5 work in the case of an email like the one you've just shown us? Because that has a temporal sequence of signatures. How does typing of 2 names in an email fit with that?
Well, my lord, I wonder whether the same question could arise where a signature, where the 2 officials sign at the same time contemporaneously. It may be difficult to ascertain who signed first in time, but the same point arises with a handwritten signature as it does with an email signature.
No, because if it's handwritten signatures, it's very hard to ensure that it's done simultaneously. Try it. You could try. But there we go. But there is nevertheless, the point is, it suggests that it's talking about wet signatures, doesn't it?
Apologies, my lord, I didn't hear that because...
It suggests that it's contemplating wet signatures.
I would submit not necessarily, because it's not. In fact, I take the point that it is hard to sign a document by hand at the same time, for two people to sign at the same time. It's not impossible. And Section 5 is, unlike some of the other provisions which I will come on to, and unlike Section 1, Section 5 is more of an inward-looking provision as to the significance of the people who sign for internal purposes. What does it mean that those signatures are there? Whereas the other provisions in Chapter 2 of this document that I will come on to are outward-looking as to who has authority to bind the bank and how the bank comes to be bound to a transaction or operation. Now, Professor Mendoza's evidence at trial, Professor Mendoza was the defendant's expert at trial. He referred to this model as a model of decentralized control. So in other words, the maximum power of the president is delegated, but is exercisable only if two officials of the relevant rank act or approve the operation. I'm not going to go to it, but that's first supplemental bundle, tab 28, page 132, day 4 transcript, page 134, line 9 and following. And I pause here to note that the two signature requirement, it's not unique to BNC. It's not a quirk of BNC. Banks and financial institutions quite often require transactions to be signed off by more than one individual before the bank is bound. And that was the case with ICBC. So the alleged assignor of the rights to CRF had signature books, which were in the trial bundle before the judge. And there are several examples of it. And those signature books bore striking resemblance to BNC's own, including by splitting up the signatories into different categories. So it's not something that's peculiar to BNC. And for what it's worth, although it's analytically perhaps not relevant, but CRF knew about this because they had been sent the signature book. So looking back at the BNC rules, we see that Section 4 classifies, or rather specifies 3 types of signatory, A, B, and C. Section 5 we've already looked at. Section 10 provides that A and B signatories shall bind the National Bank of Cuba in its relations with any other natural or legal Cuban or foreign persons, either domiciled and or residing abroad or in Cuba, regarding any transactions denominated in Cuban convertible pesos or its equivalent in freely convertible currencies, entered into between the bank and such persons. So A and B signatories have power to bind the bank in its relations with any other person. Section 11 says 2 C joint signatures, so those are the most junior officials, shall be used only to confirm balances, offer explanations, request information or documentation, as well as to deal with any correspondence, etc. So their powers are fairly limited, but even the rather mundane tasks required 2 signatures. Section 12, and we're now getting to the more important provisions. Section 12 says 2 A and B joint signatures shall be required for all banking transactions, operations, that create an obligation for the National Bank of Cuba on the basis of the type of transaction and amount involved as described in Section 17 below. Now, a few points to note here. Firstly, there was a dispute at trial about whether this is the correct translation. So the word create, we said should say represent, but that's not relevant. I simply note it for completeness. The judge found that consent to an assignment was not a banking operation that created an obligation within the meaning of Article 12, Section 12. And that finding is not an issue on this appeal, on Article 12. And the important point here is that BNC's case at trial was that the two-signature requirement applied either because of Section 12 or because of Article Section 15L. And this is very important. That's how the judge approached it in the judgment of paragraph 327. I'll come on to it. But the critical point is that if Section 12 does not apply, it does not follow that two signatures are not required, because then one has to look at Section 15. And Section 15 is not coextensive.
It is alleged by the respondent that you didn't plead Section 15L.
That's correct, but they did, and we joined issue with them. And I'll come to show you that. So there's no doubt in my submission that the point was in issue, and as I'll come on to show, expert evidence was adduced on it. And that's how the judge understood it. So
was it in the list of issues?
15L specifically, I don't think was in the list of issues. But perhaps I can show, while we're on this, I can show the court a paragraph in the judgment where the judge sets out what our case is. So this is tab 8 of the core bundle. Paragraph 301.
301.
301. Did the heading to 301 is, did BNC's employees and agents have actual authority? Then 301, the judge says the crux of the issue relates to whether, in order to have authority to give prior consent, the consent had to be given in a particular form with two signatures. And then the defendant's case is that, 1, the BNC rules regulate the conditions for the exercise of BNC's power, and 2, the authority of BNC's officials to act in the name of BNC. Fine. Point 2, and this is the important point. Approval of an assignment of BNC's debt, and insofar as it is relevant of a Cuban state guarantee, is a banking operation within the meaning of Article 15L and or 12 and or 17 of the BNC rules, and thus requires 2, in the case of Article 17, Category A signatures. So the judge was in no doubt whatsoever as to what our case was, and the reason why it was clear to all what our case was is because it was pleaded. And I'll take this slightly out of sequence and show the court the relevant passage in the pleading. So this is CRF's reply, second supplemental bundle, tab 19. The court should have the re-amended points of reply. And if we go over the page 71, paragraph 20.2, CRF pleads, without prejudice to the foregoing, it is denied that the requirements set out in section 17 of the BNC rules apply to the assignment to CRF of ICBC's rights. And then goes on to say, section 17 expressly only applies to banking operations listed in section 15 and or applies to banking transactions with a monetary value. The assignment of ICBC's rights to CRF is not a banking operation listed in section 15 and or has no monetary value. So that was their case. There wasn't a banking operation within the meaning of 15.
It seems to be about assignment. I thought the issue was prior consent.
Well, yes, but the point is that everyone uses them. That's just used as a shorthand assignment.
Really? That seems to me to be risking a great deal of confusion.
Well, my lord, we will.
Tell me if I'm wrong, but I thought the issue was whether there's prior consent.
Well, quite. I mean, but this case has nothing to do with BNC assigning its own debts and rights. So why would they be pleading anything to do with that? The point that we understood CRF to be making is Section 15 does not apply to the present case. but we can put it neutrally. Then there was a rejoinder to this, unusually, which is not in the bundles, but the rejoinder said nothing about that paragraph. There was simply an express joinder of issue at the beginning of the document, which would normally be the case anyway with a reply. If there's no admission, there's a joinder of issue, and that is the case. So section 15, and whether it applied to the present case, was a pleaded issue. It was pleaded by them, but it was an issue because we did not admit it. So the pleading point that my learned friends make, we say, is not a good point. And anyway...
But this seems to be about section 17. I'm baffled. It seems to be responding to something about section 17. So this suggests that you were relying not on section 15L, but upon section 17. And they say, well, it doesn't apply.
Yes, but my lord, the only way one gets to section 17 is through other provisions.
So that would imply that you should have pleaded the other provisions through which you get to section 17. I mean, tell me I'm wrong.
Well, my lord, the point, I accept that in our...
Don't we need to see what this is responding to? Because it seems to be responding to paragraph 5 of your defence. So why don't we have a look at that, and then we can actually see what it is that they're saying.
Yes. Sorry? Sorry? Not too much time. Yes, it's in the call bundle.
Sorry, in the call bundle?
Tab 12. Page 186. Thank you. Sorry? What's it responding? Yeah. So 20. Yeah, so it's quite difficult because we don't have the full version of the reply, but the paragraph we looked at is responding to paragraph 20 of the defence.
Oh, thank you.
The heading is BNC's employees and alleged agents. It's quite a lengthy...
Sorry, which page?
Yes, page 199 of the core bundle.
Thank you.
Yes.
So it starts at 199, but it's a very lengthy paragraph. And the provisions of the BNC rules in the Cuban Civil Code are pleaded in the sub-paragraphs. So subparagraph B pleads sections 1 and 4 of the BNC rules, and C
is the one...
section 17.
Yep.
And it is, yeah, correct, and I absolutely accept. What's not pleaded here is section 15, nor 12. But what the CRF said in response is, well, section 17 doesn't apply because section 15 doesn't apply, and there was a joint of issue on that. And the judge clearly understood that our case was, as set out in paragraph 302 of the judgment, which is that approval on assigned to BNC's debt was a banking operation within the meaning of 15L and or 12 and or 17.
I think it's a little bit clearer at 322, Judge.
Yes. Yes, it's explained in more detail there. And my lord, I will be going through 322 and the paragraphs following in some detail when I come on to the judgment. But yes, again, 322 makes it clear that we were relying on 15L and also 12. And can I, and this is relevant to my Lord's, Lord Justice Arnold's question earlier. Paragraph 321, just above that, says the next question which arises is whether there are any requirements of Cuban law alleged which go to their actions, that's the officials' action, on 13th of June and 22nd, 25th of November. Now, what happened on the 13th of June? Only one relevant thing happened, which is the email was sent by Miss Marty, which the judge had...
I'm sure you're going to have to take me back. That was paragraph...
321.
Yes.
Which refers... So this is where the judge moves on to consider the BNC rules and says the next question which arises is whether there are any requirements of Cuban law alleged to go to their actions on 13th of June. And my point is that the only relevant thing that happened on the 13th of June is the email was sent by Miss Marty. So the judge is clearly proceeding on the basis that if the BNC rules are otherwise applicable, in other words, if you get through the gateways in Article 15 or 12 and a two-signature requirement applies, that would be relevant to what happened on the 13th of June, i.e. the email. Anyway, that's more of an aside, simply to address further my Lord's question from earlier. But going now back to the BNC rules, tab 4 of the first supplemental bundle. The point, as I recall, that I was on when we turned to the pleadings, is to draw a distinction between Section 12 and Section 15, which we say is a very important distinction, because the two sections, 12 and 15, are not coextensive. In other words, not every banking operation that would fall within the terms of Section 15 is a banking operation that creates an obligation for the bank. And I will come to develop that point. But I would like the court to bear that important distinction in mind. Section 13 says that an A signature shall be required for the purpose of signing any written opinion, guideline, or clarification in circumstances where such opinion, guideline, or clarification does not compromise the policy of BNC. So this is the only case in which an A signature, as in a single signature, it is sufficient. But it's not relevant for our purposes. Then Section 14 over the page is about issuing and endorsing money orders. Again, it's not relevant for our purposes. And then we get to Section 15. Both an A and B joint signature or 2A or 2B joint signature shall, in accordance with Section 17 below, be required for the purposes of authorizing and executing the following banking operations, namely. And I just pause there to observe the reference to Section 17, in accordance with Section 17 below. This was the point to which I adverted earlier. One doesn't get to 17 unless one is into the BNC rules through one of the gateways, one of which is Article 15. If you're through one of the gateways, then you consider the value threshold in 17. Then Section 15 has a long list of banking operations.
So what you're saying is that in relying upon Section 17 as you did, you were necessarily relying on Section 15.
Yes. And that's how CRF understood it, because in their reply, they said, well, you don't get to 17 because you're not through 15. So then, I'm not going to read all of the paragraphs, but can I ask the court, please, to note, subclause J, one of the operations was to open and close accounts with other banks and natural or legal persons located in Cuba or abroad. This illustrates the point that I made earlier about Section 15 not being coextensive with 12, because closing an account doesn't create an obligation for BNC, but it is still an operation that requires two signatures, depending on the value. K, to approve any accounting vouchers and notices related to any of the above transactions. And then finally, L, to carry out any other banking operation in accordance with international standards.
Can you explain to me what is meant by in accordance with international standards?
Well, my lord, I can't explain that because there was no evidence as to what that meant. But no point was taken on it. Nobody suggested that that qualified the reach of the provision in any relevant way. So any other banking operation...
So do I understand from what you just said that the parties proceeded at trial as if those words weren't there?
I would, the way I would put it is they proceeded at trial as if the words were there, but were not relevant.
Seems surprising, but okay, so be it.
The points that I asked the court to note here is that there is, firstly, there's no express limit on the nature of the operation. So there's any other banking operation subject to the international standards point. There's no implied limit either. None was suggested by Professor Mendoza or Ms. Rodriguez. As I mentioned earlier, there was no evidence of any Cuban court interpreting this, no academic commentary as to what it means. All that the judge had at the end of the day is the unvarnished language of the provision.
Well, that's an interesting point, given that you've repeated it. Can I ask you this question? You're making the point that we can interpret this for ourselves. But if we are interpreting it for ourselves, I find it very hard to ignore the words in accordance with international standards, because those words seem to me to be highly relevant to trying to understand what on earth this is doing. And one immediate possibility that occurs is that what this is saying is, well, where the international standard says you need 2 signatures, then these are the 2 signatures that you require.
Well, my lord, yes, but as I made the point earlier, which is this was not explored at trial at all. There was no evidence of that on that point. One could speculate as to what meaning could be attached to it.
Either it's a question of evidence, or it's a question of the court interpreting the words for itself. Now, which is it?
My lord, either. We'd put our case in both ways.
All right.
You say that the judge interpreted the words for herself without any additional helpful evidence. She just looked at that because that's what she was asked to do.
Yes, but I would caveat that with that the judge, in her judgment, does refer to evidence on the scope of the BNC rules. The point we make is that she refers to the evidence on Article 12 and elides the distinction between 12 and 15. So the judge did rely and refer to expert evidence, and I will come on to show the court what the judge said. So the judge did not simply look at the words and interpret for herself. She did rely on the expert evidence. But my point is that the expert evidence, I'll come on to this, but it was extremely brief. There was no live Cuban law issue as such. Professor Mendoza said that this is a catch-all provision, words he used, and Ms. Rodriguez said nothing about it, except orally in cross-examination, but not in her report. And again, I'll come on to that. So the question that arose at trial was whether the giving of consent to an assignment, the effect of which is to bring BNC into a contractual relationship with a new counterparty, was any other banking operation in accordance with international standards within the meaning of this provision. And we said it is, and we say that the expert evidence on analysis was actually all one way, and I'll come on to develop that. And then section 17, which is the provision that we did plead, states a banking transaction where a signature by the National Bank of Cuba is required, section 15 above, so again, cross-reference back, shall be signed as follows. Up to 300,000 2B signatures, and then it goes on various combinations. USD 5 million and above, 2A signatures required, including a signature by either of the Director of Documentary Credits, the Director of Operations, Director of Accounting, Chief Operating Officer, the Vice President, or the President. So Ms. Marty, who sent the 13th of June email, which the judge found was consent as a matter of English law, was an A signatory at the relevant time. Her position was Foreign Debt Office. Manager of the Foreign Debt Office.
Get into the details because, as you say, it's plain that the email only has one name on it. So if two names are required, then it's plainly insufficient.
There's only one other point which I need to mention because it's relevant to the respondent's notice argument. Or I could save it in reply. I'm happy with that.
Go on and make the point.
The point is this, that Mr. Lozano, who was appointed as Director of Operations, so that's one of the officials who are named here. The significance of that, we say, is that Section 17 and the scheme of the rules presupposes that there are individuals appointed to these roles, including, for example, the Director of Operations. And the appointment is carried out by a separate resolution of the President of the bank. We say that once that person is appointed to that position, one must look to this instrument, the B&C rules, to work out the scope of their authority to bind the bank. And what you cannot do, we say, is proceed on the basis that by appointing the person, the official, to that position, the President is delegating their authority to approve transactions by a sole signature. That's the point made, as I understand it, by my learned friends. A respondent's notice point 1, they rely on Article 54 of the B&C Statutes, so I'll come on to that. And they say, because these individuals are appointed by the President, they're delegated the authority to sign, approve by their sole signature. And we say that is wrong, and for various reasons.
They go further, they say that's what the judge found.
In fairness, I think
paragraph 26 of their skeleton.
Yes, I thought they, from memory, they accept the judge didn't make a finding, but we say the judge made findings that are inconsistent with their case.
They say that your ground one must inevitably fail because you don't grapple with the judge's finding.
Yes.
Ms. Marty
yes.
had delegated authority.
Yes.
And they say that you're not challenging that finding.
Yes. Well, we are. We are challenging. It's the grounds of appeal refer specifically to the 13th of June email. I will come on to this, but
there's something on that. Certainly, we're going to have to look at the judgment.
Yes, of course. Yes, and I will
work out what the judge actually did find.
Absolutely, and in some detail, my lord, I'm going to go there. Yeah. But the reason I'm going through the rules and the evidence first is because that helps to, we say, to understand what the judge.
To be sure, and that's perfectly logical. But I'm still deeply puzzled as to how any of this applies to what we're concerned with here. Can you help me on this question? Let us assume that this might be applicable to an email. Now, is it your submission that when one finds two typed names, the requirement of two signatures requires the person typing each name to be the person who is named? So if Mr. Lozano's name appears in the email, it must be Mr. Lozano who typed that name. And if Ms. Marty's name appears, it must be Ms. Marty who typed that name. So they must each separately type their own name. Is that your submission as to how it works?
Well, my lord, I don't make any particular submission at all on the mechanics of that. It's simply because it didn't arise at trial, and because there was no expert evidence or no factual evidence, and no evidence as to what the computer systems were at BNC, I would simply be making a submission that was entirely speculative. And I don't need to make the submission. It's not necessary, we say, for the court, for this court to get into that.
Well, you say it would be for the respondent to demonstrate how the 13th of June email satisfied 15L.
Yes. Yes.
If
Yes.
it needed to be satisfied.
Yes.
But that doesn't arise because in any event there's only one name.
Exactly.
So
Exactly.
in a sense you say it just...
It never arose. It doesn't arise now, we say, for that reason. That's...
But you were taking us in section 17 to the named positions. And your point, I think, was the fact that they are named positions, but nevertheless you need two of them, as is described, is contrary to a submission that might be made to the effect that nevertheless holding one of those positions meant
Yes.
that you had sufficient authority
Yes.
on your own.
Yes.
Can't do
That's the
both.
short-
That's
yeah.
what you were saying.
Yes, that's the short point, and it's one of the points we make in the supplemental skeleton. I appreciate the court hasn't had a chance to read it, but that's one of the points we make in response to their Article 54 case. We've got various other points as well.
Okay.
The reason I picked it up here is because it arose on Section 17.
And perhaps, I don't know whether you make a point in relation to the next paragraph there under section 17, which is the reference to sole signing authority
Yes.
being that of the president.
Yes, absolutely, and that's we do rely on that, and we also rely on the last sentence, which says the provision of section 15 above shall be construed in light of the thresholds in this section 17. So the two must be read together, and that's clear. If we then, so that's all I have to say on the B&C rules. Of course, I will have a lot more to say on the judge's findings on the B&C rules. I'll come on to that. B&C statutes is the next document. Tab 1 of the same bundle. So, page 1 of the bundle, resolution number 1 of the president of BNC. Sometimes we see this document referred to as the bylaws, sometimes as the BNC statutes. They're dated the 15th of December, 1998. We see that at the very last page, page 13. If I could show the court first Article 14, under the heading Senior Management President, Article 14 states the President is appointed, well, it sets out how the President is appointed. Article 15 says that the President is the legal representative, and I used that expression earlier when I referred to Professor Mendoza's description of decentralized control. Article 18 provides that the President, when exercising his or her authority, can grant the powers he deems necessary and delegate his or her authority to other managers and officials of the bank. And if he does so, it shall in no way imply that his or her responsibility ceases. And so on. So the President can delegate his or her authority, and the President can also issue binding resolutions and appoint management personnel. We see that in Article 20, A and C. We then get to Article 40 next, if I may. Those are the provisions dealing with second and third management levels at the bank. setting out the duties, powers and functions of the managers at those levels. And these provisions applied to Mr. Lozano and Ms. Marty. And can I show the court, please, the judgment and what the judge concludes in this regard? So, Core Bundle, tab 8, page 146, paragraph 314 to begin with.
314.
Please.
Oh,
sorry, page 145. 145.
Yep.
I apologise. So the judge in this section, and we already looked at page 143, having summarised the parties' cases, then says this at 314. Each of Mr. Lozano and Ms. Marty was in the face of it apparently a delegate of the president of BNC. Mr. Lozano was appointed by the president of BNC to the position of Director of Operations, and then there's a reference to resolutions, and Ms. Marty was appointed by the president of BNC to the position of Manager of the Foreign Debt Office. Both were positions specific to BNC. The question was then what that entitled them to do. And the judge then considers that question and makes findings at 319 and 320. So having considered CRF's case on the drawing of an adverse inference in the disclosure context, the judge says that's immaterial. 319, this is because even considering the matter without reference to this possibility, so the drawing of inferences, the position is still tolerably clear. And can I just ask the court to skim read then subparagraphs 1 and 2? So the judge there refers to Articles 40, 41A, 41B and 41H of the BNC Statutes, which I showed the court. And then the judge says this at 320. Subject, therefore, to any requirements of how they were to go about performing actions pursuant to the delegated authority, Mr. Lozano and Ms. Marty had authority to act for BNC in relation to consenting to the assignments. And then the judge goes on to examine the application of the BNC rules. Now, the words that I emphasize are subject to, because the judge clearly, having found that Mr. Lozano and Ms. Marty were delegated the relevant authority, did not simply stop there, but went on to consider whether the two-signature requirement in the BNC rules applied. The point being that the exercise of the delegated power from the president to those two individuals was subject to the requirements of the BNC rules if they were otherwise applicable on their own terms. And that's why the judge then goes on to examine the application of BNC rules in some detail in a passage that's not obiter, but critical to the judge's decision. And I will be going through, as I say, the subsequent passages in detail. But I note this point because this is another reason why we say that CRF's Respondent's Notice Point 1 is not a good point, because it contradicts the judge's analysis. Simply because Ms. Marty and Mr. Lozano were appointed to their roles by the President doesn't circumvent the application of the BNC rules. That's not how the judge approached it. The exercise of the authority was subject to the BNC rules if they were otherwise applicable. And we can find further support for that submission and to contradict the Respondent's Notice Point. Paragraph 337, if we skip forward, at page 150, where the judge considers our case, that the requirements of the rules were mandatory. So if we look at the second sentence, CRF contended that there was no requirement under the rules for 2 signatures, and that even as regards a banking operation which fell within the ambit of Article 15, the requirement for 2 signatures was not a mandatory one. However, if that were the case, it is hard to see what point, or the point of Article 15 is. Either it sets out a requirement or it's a waste of ink. And as I understand the case being advanced before this court by CRF, is that indeed it is a waste of ink, because Mr. Lozano and Miss Marty did not have to observe the requirements of the BNC rules because they were delegates of the President. And we say that's wrong. And just staying with the respondent's notice point while we're on the statutes, can I show the court Article 54, page 12? It says, in its external relations, the bank shall always be represented by its president or by the manager or officer to whom he has delegated that responsibility. In addition, external relations can exist at the various levels of management by the respective managers or authorized official. In such cases, they only commit their respective positions or the organizational units dependent on these, except in the case of managers and officials given the authority by the bank to sign documents in its name. As I understand the argument, emphasis is placed on the words "in addition" at the beginning of the second paragraph by CRF to say what this means is it creates a dual regime. There's the BNC rules, and that's how you can be given authority to sign, and if you're in the BNC rules, 2 signatures applies, or you can be delegated authority and thereby circumvent the BNC rules. And that's the first paragraph, and we say that's wrong, and there was no evidence to that effect at all. And such evidence as there was undermined CRF's case. The references are in our supplemental skeleton, paragraphs 3 and 4. But I've said quite a lot already about the respondent's notice point. I have quite a lot more to say, but I'll wait to see how my learned friend Mr. Kirsch develops it orally. And if he does, I will have more to say in reply. But the supplemental skeleton, so far as it deals with Cuban law, deals with this point, the respondent's notice point. It doesn't deal with our case on ground 1. So that's the BNC rules.
That's one thing. As I understand it, your case would be that consent to assignment would require 2 B signatures at least. Is that right?
In this case, 2 A signatures.
Why 2 A signatures?
Because the value of the rights that were being assigned and to which consent was given was in excess of the 5 million threshold.
I see. Now, if it has 2 A signatures, there is authority. If there are not 2 A signatures, there is not authority. Is that right?
Yes.
So in what sense is their delegation to Mr. Lozano and Ms. Marty to act for BNC in relation to consenting to the assignments, as the judge found in 320?
Well, the way, as I read the finding of the judge, as I understand it, Mr. Lozano and Ms. Marty, one of their functions, responsibilities, was to approve assignments such as these. And if one of them did so, they were not stepping outside the scope of their functions and responsibilities entirely, because it was their job. But the question was, is the bank bound by that act of giving consent? And in answering that question, one looks at the BNC rules and whether the 2 signature requirement applies and was fulfilled. That's how I...
That seems to be a submission that they didn't have authority. That the only way they had authority was if they both signed.
Yes. I mean, the concept of authority can be, I was about to say slippery, maybe not slippery, but not easy to apply when what one is doing is trying to map on what we understand to be authority in English onto the Cuban law context and the BNC rules.
I don't think it's a matter of they had authority if they signed. I think the point is they had authority to sign.
Yes.
Because they were a signatory.
Yes.
Or in Mr. Lozano's case, he was a nominated director.
Yes.
And that was their authority to consent to an assignment. That's the only relevant authority here, because either they exercised that authority or they didn't.
But the point, the point we make, and we say this is how the judge approached the subject to point. So if the BNC rules require 2 signatures, and only Mr. Lozano signed,
that's why I struggle, because if they don't put their signatures on, then there isn't authority, and the authority to put the signatures on isn't dependent upon anything other than the fact that they are authorised to sign.
Yes.
I don't understand how there's any room in that analysis for any other delegation. What are they delegated to do?
Well, they're delegated. They're delegated the functions of the authority the judge says they're delegated, 320. But if they, in exercise of that, one of them puts a signature on a document or approves an operation, that doesn't bind the bank unless there's another.
They don't have delegated authority to do it.
Yes. Yes. Now I see
they only have delegated authority to sign.
Yes.
And it only binds the bank if there's 2 of them.
Yes.
So they individually do not have delegated authority to bind the bank.
In the relevant sense, perhaps. Yes.
In any sense.
Yes.
And to put it another way, as I understand what you're saying, and please correct me if I'm wrong, in relation to paragraph 320 and position is, Mr. Lozano and Miss Marty were of the correct character or status because of their appointment to their particular offices, which meant that they were the appropriate people to sign in these circumstances. But then the bank is only bound when it's signed properly in relation to 12 and 15 and 17, etc.
Yes.
And so if somebody from the post room had been one of the signatures, that would not have been enough, of course, because we're talking about A, B, and C signatories, but it was just because of their status that they were appropriate people. That's all you're saying about 320.
It is.
Is that right?
Well, that is what I'm saying. That's how I read the judge's findings. Yes.
Thank you.
But Miss Marty's status, relevant status, isn't as head of foreign debt office. Her relevant status is as an A signatory.
Yes.
The only sense in which the power to authorise consent is delegated to her is in her capacity as an A signatory.
Yes. And exactly. And perhaps another way, and I'm not sure if this is another way of putting the same point or it's a related point, is that the delegation was subject to a condition, in other words. So they had authority subject to the condition of complying with the BNC rules, which imposed the 2 signature requirements, we say. But whichever way one analyses it, and I accept that there perhaps is more than one way of interpreting the findings, what we say is reasonably clear is that the judge approached it on the basis that if the BNC rules were otherwise applicable, in other words, if this was a banking operation within the meaning of the rules, then the 2 signature requirement applied, and if it was not complied with, the bank would not be bound. That's the mandatory point which is addressed later in the judgment. So that's how we read. And myself, I've never really understood the point on Articles 40, 41 and so on that CRF was advancing a trial, the relevance of it, because it's quite clear, we said and we accepted, and that these two individuals, it was their job to consider and approve assignments. And there was no getting away from that fact. The question is, what did they need to do to bind the bank? And we said they had to comply with the requirements of the BNC rules. So that's what I have to say on the BNC rules, but I will come back to that part of the judgment again. But first, I'd invite the court to look at the expert evidence that was before the judge on this issue. There were two experts on Cuban law, Professor Mendoza called by us, Ms. Rodriguez by CRF. And the judge's assessment of the two experts is at paragraphs 209 to 213 of the judgment. I don't propose to take the court to those paragraphs, but I simply note that what the judge observed is that Professor Mendoza had, on the face of it, significantly greater expertise and was the better live witness, but the judge found that Ms. Rodriguez's evidence read better in the transcript than it sounded live, and her written reports were overall clearer. The judge also observed, however, that she was entitled, and indeed required, to bring her own training and experience to bear on the questions of Cuban law, and that is what she did. And we say that is consistent with our submissions on Perry and Lopak. That's paragraph 213 of the judgment. And if I can just...
And she found neither witness to be particularly clear in the evidence.
It's not therefore a case where I found myself able simply to prefer the evidence of one witness over another across the board. The evidence of both experts needs to be weighed on each point. In doing that, I am entitled, indeed required, to bring my own training and experience to bear. In the event, bearing in mind all these points, using the sources to evaluate conflicts, I agreed with each expert on some points, but not on others. Professor Mendoza's second report is in the first supplemental bundle, tab 18. And just for the court's reference, his first report was served in May 2020 in support of our jurisdiction challenge. That report is not in these bundles, but it was before the judge. Whereas his second report, which is this report, was served specifically for the trial. And it is dated, or it was served on the 2nd of September 2022. And the reason I asked the court to note the date is because expert evidence was served sequentially. We went first, and then Ms. Rodriguez had the opportunity to address in writing what Professor Mendoza had said. Page 62 of the bundle, just above paragraph 87, is a subheading which identifies the question that Professor Mendoza was asked to address. Do the BNC rules on signatures apply to consents to the assignment of sovereign debt? Please consider paragraph 20.2 of the amended response points. Now, this is a translation, so amended response points is the amended reply that we looked at. Paragraph 20.2 of the amended reply, where CRF specifically pleaded that section 15, article 15 of the rules didn't apply. So Professor Mendoza was asked to address that. Now, the reason I emphasize that and the words consent to the assignment of sovereign debt is because a suggestion is made by CRF that our evidence at trial was somehow misdirected to the question of BNC itself assigning some debts. But it wasn't. That's not how the question to Professor Mendoza was put. That's not how he understood it. And that's not the opinion he gave. This case has nothing to do with BNC assigning anything. It has everything to do with it approving an assignment. So that's the question. And the answer that comes back from Professor Mendoza is this. At 87, he says, as I set out in my first expert report, summarized above, BNC resolution, so that's the BNC rules, applies to the provision of consent to the assignment of public debts. By way of further clarification, the effect of Article 15 of BNC rules is that it applies to all banking operations conducted by BNC. In this sense, Clause L of Article 15 acts as a catch-all provision designed to cover all banking operations of BNC. And then he quotes Article 15L. So I would submit it was clear and obviously clear to the judge because she had understood our case correctly, that Article 15L applied to the giving of consent to an assignment. So that's what Professor Mendoza said. Then, if I may to show you paragraph 94 of the report as well, which is page 64 of the bundle. The question that Professor Mendoza was asked was Ms. Marty authorized to act on behalf of, I should say BNC, with respect to the consent of the sovereign debt assignment? What was the scope of that authority? And he says, Ms. Marty was designated Type A signatory in the BNC signatures book and consequently had the same authority as that set out in respect of Mr. Lozano, paragraph 92 above, with the exception that as manager, she was only authorized to carry out a transaction on behalf of BNC in excess of 5 million jointly with one of the senior officers referred to in Article 17. And a cross-reference to paragraph 92, the court will see that in 92, Professor Mendoza refers to various aspects of the BNC rules. 92E, he refers to Article 15 specifically, and Article 17. So those are the provisions that he said governed the authority of Ms. Marty to consent on behalf of BNC to an assignment. And this point, I emphasize it because CRF say in paragraph 32 of their skeleton that our evidence was directed to the 25th of November 2019 document, which was signed by Mr. Lozano, and not the 13th of Junima, which was signed by Ms. Marty. But here, Professor Mendoza is specifically considering Ms. Marty's authority to bind BNC, and he does so specifically by reference to Articles 15 and 17 of the BNC rules. Then, that was Professor Mendoza. Then, on the 22nd of October 2022, we have Ms. Rodriguez's first report. So it's served after Professor Mendoza's report. Tab 19 of the first supplemental bundle. And if we go over the page 69, question 14 is the relevant question. Ms. Rodriguez is asked, do the BNC rules on signatures apply to consent to the assignment of sovereign debt? Please consider paragraph 20.2 of the amended reply, I should say. So she's asked the same question. At 8.48, she says, in my opinion, BNC rules do not apply to consents to the assignment of sovereign debt for the following reasons. Then in the next paragraph, 8.49, she refers to section 12 of the BNC rules. If I can ask the court to read that, please. So 8.49 addresses section 12. And then 8.50 addresses section 15. And Ms. Rodriguez says the types of transactions are listed in section 15 of the resolution. Section 15 states that both an A and a B signature, or 2A and 2B signature are required, depending on the monetary value of the transaction set out in section 17, for the purposes of authorizing and executing certain listed banking operations, including operations F, to borrow, grant short, medium, and long-term loans of financing, or G, to receive and authorize any sight and term deposits. Now, what Ms. Rodriguez does not do is she does not mention L. She says nothing at all about L, even though that is the one specific provision that Professor Mendoza identified as relevant in his second report. She doesn't say anything. She goes on to say at 8.51, the relevant operations do not include the act of BNC giving its consent to an assignment for one or more of the following reasons. The first one is this: the act of giving consent to an assignment is distinct from the assignment itself. The act of giving consent to an assignment is the performance of an existing contractual obligation under an existing loan agreement. The act of consent without more does not create an obligation on BNC. So clearly, this is a reference back to Article 12, the creation of an obligation, and has nothing to do with Article 15L. She says it merely permits the existing creditor to assign its existing rights to a new creditor. And the next point, at 8.51.2, again talks about creation of new obligations. And the last point is to do with the monetary value. And nowhere here does Ms. Rodriguez address the only relevant question, or at least one of the relevant questions, which is the consent to give consent to an assignment a banking operation within the meaning of 15L. She doesn't address it. And a fair reading of this part of her report, or at least one possible reading, is that she did not in fact disagree with Professor Mendoza on that point, because if she had, she would have said so. Then we have the joint report, tab 20 of the first supplemental bundle. The joint report is a difficult document, difficult to follow, and it's difficult to make sense of. But it's also not particularly relevant, but I'm showing it to you for completeness. If we look at page 73, the question number is identified in the left-hand column, and there's a slightly garbled translation of the question, but it's the same question that we saw referred to in both of the expert reports about granting consent to an assignment. The middle column says there's no agreement between the experts, and then Professor Mendoza's column is the second one from the right, and Ms. Rodriguez's column is the last column on the right. And she simply cross-refers to paragraphs of her report. So it's not a particularly illuminating document, but the experts stick to their whatever opinions they've expressed.
You say that, and plainly Professor Mendoza hasn't retracted what he said, but does he actually refer here to Article 15L? Because I can't see it.
He does not refer to Article 15L, but clearly he hasn't resiled from his opinion.
No, clearly not.
And he makes that clear, abundantly clear, in the next document, which is his third report, tab 21. Where on page 76, there's a heading, question 14, so we're still with the same question. And Professor Mendoza says, in response to question 14, Ms. Rodriguez believes that the rules for signatures fixed in the BNC rules do not apply to assignments. And my Lord, Lord Justice Arnold, question earlier about the distinction between assignments and consents to assignment. There's clearly a very important distinction, but this shows that the expert uses it as a shorthand, clearly, because Mr. Rodriguez's opinion was about consents to assignment, but the shorthand is assignment. And we see that again at paragraph 31.2.2, where Professor Mendoza addresses Article 12, but also in the same paragraph, in the last third of it, he says the requirement of a dual signature for an act of assignment is also confirmed by the terms of Article 15, which regulates the joint use of type A and B signatures. In Section L, establishes they will be used for any other banking operation in accordance with international standards in which the assignment of a debt is included. And again, I say the only fair reading of that is that he's referring to consents to assignment, because that's what the question was about, that's what his first report was about, and that's what the case is about. Now, Mr. Rodriguez's second report is not in the bundle, and the reason for that, presumably, is that she says nothing at all about question 14. We then come on to the cross-examination of the experts. First, Ms. Rodriguez. If we could look, please, in tab 29 of the first supplemental bundle. This is day 5, transcript of day 5. And if I could please ask the court to start at internal transcript page 52, page 138 of the bundle. At line 13, where I say, and I was putting the questions to Ms. Rodriguez, if we look at the next paragraph, L, so this is Article 15L of the rules, to carry out any other banking operation in accordance with international standards. So that covers any other banking operation which is not already listed in the paragraphs above. Correct? Correct. So what I would like to explore with you, please, first, is how these provisions might apply to an assignment of debt. I think we can agree that an assignment involves three parties: an assignor, who's the existing creditor, the assignee, who's the new creditor, and the debtor. Correct? Yes, correct, of the page. Now, let's assume that in order for the assignment to be effective as against the debtor's approval is required. So can we please make that assumption? If approval is given, then the obligation that was previously owed to the assignor is now owed to the assignee. So that's the hypothetical scenario I would like you to consider, please. And then Ms. Rodriguez asks me to reformulate the question. She says, I think you're referring to consent to the debt assignment. Is that right? I said, yes, that's right. Yes, so we're agreed. Line 14. So in that scenario, the giving or withholding of approval to the assignment by the debtor is a banking operation within the meaning of Article 15L, which we have looked at. Do you agree? The answer is, it is a banking operation. Well, at point L is a wide norm which could involve any banking operation in line with international practices. Yes, and then what we see in the transcript is there's some disturbance, someone entering the room, and there's an exchange about that. And then at page 54 of the transcript, line 13, we pick it up again a few moments later. And I say, we were looking at Article 15L and we were considering the assignment scenario. My question is, if something like an approval of accounting vouchers and notices of banking operation, approval of an assignment is likewise a banking operation, isn't it? Then I'm asked to reformulate the question, which I do, or try to. And then at page 55 at the top, the question, I ask this question. If under K, something like approval, an accounting voucher or a notice constitutes a banking operation, then it follows, doesn't it, that under L, approval of an assignment would likewise be a banking operation? And the answer is, according to the regulation, yes, it could be considered the same. Yes, well, I say, yes, it is the same, and that's correct, isn't it? And she says, yes. So Ms. Rodriguez, having not addressed Article 15L in writing, is then asked a question about it and confirms that an approval of an assignment would be a banking operation within 15L. Now, a point is made against us that that this was a question, or was understood as a question about assignment, BNC assigning something. But clearly it wasn't, because the hypothetical that I described made it clear. We're talking about three parties, talking about approval of consent, and the question itself refers to approval. So nobody was concerned with BNC assigning anything.
Well, that's clear from what Rodriguez says at 53, line 10.
Yes, exactly.
He herself defines what
Yeah, exactly. And I would submit it's crystal clear, and the suggestion that the expert somehow thought that I was talking about an irrelevant assignment by BNC is not a good one. But it is a point that's made in their skeleton, 34.3. And then, just so the court has the reference while we're here, at page internal 56 of the transcript, so the same page in the bundle, at line 13, we move on with Ms. Rodriguez to Article 17 of the rules, and there are quite a few questions about that, and can I just highlight for the court's attention, page 59, lines 8 to 16, the exchange there. I'm not going to read it all out, but that's about the value of the transactions. It's a separate point to Article 15, but it's relevant to Article 17. And again, while we're here, page 64, so over the page in the bundle, page 64 of the transcript, lines 1 to 12 are relevant in the context of my learned friend's Article 54 respondent's notice point, because that is where Ms. Rodriguez agrees about the effect of Article 17, that the directors there mentioned can't bind the bank with a single signature to operations within the scope of the rules. But I'll come back to that if necessary in reply. So that was the evidence of Ms. Rodriguez, who gave us more than she did in her report, which, as I say, was silent on the relevant point. In Professor Mendoza's cross-examination, is at tab 28, transcript of day 4, starting at internal page 130, line 20. This is where Article 15 first comes up, and I'm not going to read it all, but that's the beginning of the relevant passage. And then at page 135, from line 12, if I can ask the court to read or skim read from line 12, page 135.
I'm sorry, so...
Apologies, my lady.
No, I was going by bundle number rather than internal number.
Yes.
So I apologise
So
for
this is
that.
the next tab.
No, it's internal transcript number
Oh, I see.
135, so
Sorry,
it's
that's
page
what was
132.
confusing me. Right, yes.
Oh, apologies. So it's
Yes.
bundle page number 131 and internal transcript page 130.
Yes.
Line 20 is where the passage starts, but it's sort of...
Yeah, understood.
Got it.
I'm not going to read it all.
And then you were taking us to
The next page.
transcript page 135,
Exactly.
which is at 132.
Yes,
Yeah.
precisely. So transcript 135, starting at line 12, down to 136, line 22. And if I could just ask the court to read.
Thank you. Yes, Mr.
So
Newton.
the
Professor
submission
Mendoza
I make.
seems quite emphatic.
Apologies, my lady.
Just
didn't
Professor
hear.
Mendoza seems quite emphatic.
Yes, yes. Well, he certainly didn't give much away, and I'd submit that his evidence was consistent on this point with his written report that we have already looked at. The net result of all of this, we say, is that the only relevant expert evidence before the court was that Article 15L applied to consents to assignment. That was Professor Mendoza's written evidence. Nothing he said orally contradicted it. It was also Ms. Rodriguez's oral evidence, and she did not address it in writing. And even if she did, or had, or is taken to have done, then she resiled it from it in the witness box. So that's the evidence. We now come on to the judgment, which is the last part of my submissions. Tab 8 of the core bundle, page 143. So this is the beginning of the relevant section, and we have already looked at paragraphs 301 and 302, which identifies the issue and summarises our case. It's important to note that by the time it gets to this stage of the analysis, the judge has already concluded, firstly, that Ms. Marty's email of the 13th of June amounted to consent as a matter of English law, and secondly, that as a matter of Cuban law, BNC had capacity or power to consent to an assignment of these debts without obtaining approval from the Cuban Ministry of Finance and Prices, MFP, or the Council of Ministers. And the reason I make that point, it will hopefully become clear in a while, because it comes back into the judge's reasoning, wrongly we say, when she analyses the application of the rules. We can skip over the paragraphs that summarise and explain in more detail the parties' submissions, and if we can turn please to page 146, where we left off at the heading BNC signature rules.
Can you just help me on this? I mean, I appreciate the case you're advancing, but and you made the point that 302 sets it out. When one looks at 303, the parties' cases seem to be like ships sailing the night, because as summarised by the judge, CRF's case is not about Article 15 at all. It's not saying, as she summarises in that paragraph, it's not saying, well, Article 15 might be applicable, but this isn't within L because it's not a banking operation. Instead, it's all about Mr. Lozano and Ms. Marty having the relevant positions and having authority delegated to them.
Yes. Yes.
So one might have thought at the end of 303 that it was CRF's position that actually the BNC rules had nothing to do with it at all.
Yes. No, I see the point, my lord. And the answer may be this, that what the judge is doing as 302 and 303 is setting out the party's positive case. And what she doesn't set out, because it's not necessary in this part of the judgment, is what the parties say in response to the other's positive case. I'll be corrected if I'm wrong by my learned friend, but my recollection of their written opening is that they did actually address Article 15. I don't think I have it in the bundles, and I will check over the shorter journal, but that's my recollection, and certainly they did have a case about it, more or less in line with their pleading.
The point is that even if on their case that this wasn't a banking operation and so 15L didn't apply, it nevertheless got to establish that Miss Marty had authority.
Yes.
And this is setting out
yes.
what her authority is.
It's the prior question, exactly, yes.
Well, that would arise in...
Yes.
That's the other way to put it. That would arise in any event, and that's their answer.
Yes. Yes. But they also had the case on Article 15 as I say, is my recollection. It was put it by them in writing in their opening, but I will check. So paragraph 321, BNC signature rules. The judge says the next question which arises whether any requirements of Cuban law alleged which go to their, that's the officials' actions on 13th of June and 22nd, 25th of November. As to this, the defendants contend and invite me to find. And my Lord Justice Phillips already drew attention to this paragraph. I'm not going to read it all, but the judge summarises our case. It refers to Article 15 and also to Article 12 and 17. And then the judge says at 323, all of this depends upon equating consent to an assignment with a banking operation within the meaning of Resolution 10, 2016, so the BNC rules. It was Ms. Rodriguez's evidence that it was not. She said this, and then there's a quote. And the quote that we see set out over the page is all to do with Article 12. Because Ms. Rodriguez didn't address Article 15L, but she did address Article 12 in some detail. And those are the passages that we see set out there. But the point, and the very important point in my submission that I mentioned some time ago, is the distinction between Article 12 and Article 15. Not every Article 15 operation creates a legal obligation for the bank. They have to be analysed separately. So it's all very well setting out the evidence of Section 12 and explaining why that doesn't apply. But that doesn't answer the separate question of whether Article 15L applies. And it's an important distinction, which we, in my submission, see obscured from this point on in the judgment. So after the quote from Ms. Rodriguez on Article 12, 324, the judge says a certain amount of cross-examination was directed to the question of whether an assignment of a debt was contrary to this evidence called by the rules. The effect of Ms. Rodriguez's evidence appeared to be that she accepted these propositions, at least insofar as they concerned assignments of debts by B and C. And I pause there to observe that in my submission that's not correct. The questions which were put to Ms. Rodriguez, as we saw in the transcript, were about consent to assignment.
The judge had the transcripts?
Yes. So that's not wrong. That's not right, and it's clear on the face of the transcript that that's not right. The judge goes on to say, however, she was not asked and did not accept the proposition that consent to an assignment between a creditor and a third party was a banking operation which attracted a need for compliance with these rules. Again, a pause there and ask, if these rules is a reference only to Article 12, that may or may not be right, but that's not the relevant question. But if these rules is intended to encompass Article 15, this is clearly wrong, we say. Because she did accept that, and you can see that in the transcript. The judge continues that her evidence was that signatures were required for transactions which equated to an obligation for B and C, and that with consent to an assignment there's no amount involved appeared to make sense. There's a very real distinction between executing an assignment of debt, i.e. B and C either assigning the debt to a third party becoming the assignee of the debt, and consenting to an assignment of a debt owed by the bank between its creditor and another person. I entirely agree that there is a real distinction, but I also submit that it's one that we observed in the evidence and also in the cross-examination of Ms. Rodriguez, and the suggestion to the contrary is plainly wrong in my submission. Paragraph 325, the judge says, Professor Mendoza's reasoning appeared to come back in part to his approach to capacity and in part to an approach to the rules, which saw them as necessarily applying to all actions of the bank's authorized employees. The reasoning behind this was not clear. It did not appear to be justified by the wording of the rules, where Article 12 is clear that the 2AB signatures requirement is not a blanket obligation, but rather one which is triggered by banking transactions which create an obligation. Again, what's happening here in my submission is that Article 12 and Article 15 are being elided wrongly or treated as imposing cumulative requirements, where it was nobody's case at trial that's how the provisions are to be read. And although the judge says that the reasoning behind Professor Mendoza's conclusion was not clear, we say with respect it was entirely clear, because he described Article 15L as a catch-all provision in his report, evidence which was never contradicted by my learned friend's expert, and it was entirely justified by the wording of the rules, which is any other banking operation in accordance with international standards. And again, there's a reference, as we see, to Article 12, but no mention of Article 15L. Then 326, the judge says, this approach also seemed both impractical, as requiring a degree of formality and delay, which would be odd in cases where a transaction effectively made no difference to the bank's bottom line, and contrary to the understanding of those operating the BNC at the time. As CRF pointed out, there is no record of any previous in-principle consent to an assignment or even the confirmation of the finalized assignment being attended with such formalities. And I pause there and ask the court to ask itself, what are the formalities that are being referred to here? Because it's quite clear in my submission that the judge is not talking about the two-signature requirement at all. The point that is being made, and we see this in the subsequent passage, she says, Mr. Ali was the first Deputy Minister of the Ministry of Finance, did seek to suggest orally there had been previous requests to MFP, to the Ministry, but that did not reflect the documentary evidence which was considered in some detail in the solicitor's correspondence. That indicated that defendant's solicitors had resisted disclosure of other assignments, precisely because a search and sampling exercise from 1999 onwards had indicated that none of the documents evidenced the defendants seeking the approval of the Council of Ministers and or the Ministry of Finance and Price for assignment of Cuba's sovereign debt. So what appears to have happened here is that the judge is linking the question of the actual authority of officials to bind the bank with one or two signatures with the completely separate requirement of seeking approval from the Cuban Ministry of Finance and the Council of Ministers. And that is a completely separate point which has nothing at all to do with the BNC rules. And we can tell that from an earlier part of the judge's judgment, where the findings are made, starting at 272, So this is an earlier part of the judgment where the judge addresses our prior, analytically prior case of BNC's capacity to consent to the assignments. Starting, as I say, at paragraph 272, and the heading above that makes that clear. 273 says Professor Mendoza's opinion was that while the debts in issue fall within the scope of Article 7LL, that's of the decree law, and then 1, Article 7, self-properly construed indicates a restriction. That's supported by BNC statute Article 56. And 3, the net result was that BNC was required to obtain prior approval of the MFP and the Council of Ministers. So that was Professor Mendoza's evidence. And the judge considers it in some detail in the paragraphs that follow and reaches this conclusion at 296. I therefore conclude that BNC had capacity to consent to the assignment of the debts in issue in this case. Again, there is support for this conclusion in the later events, but though I do not rely upon this for my conclusion. In particular, 1, BNC did not in practice seek the approval of the MFP within the consent of the Council of Ministers, and such approval and consent was not provided. The defendants have accepted in correspondence that there is no evidence that any prior authorization of the MFP or approval of the Council of Ministers had been sought or provided in connection with any assignment. So this is the correspondence that we then see referred to again in the paragraph under the BNC rules that I read, which has nothing to do with the BNC rules at all. It's a completely separate point. And the judge, in this part of the judgment, treats it as a completely separate point, going to capacity only. And at 299, there's a further finding Accordingly, I conclude that Article 7 LL gives BNC power to consent to an assignment of debts contracted by BNC prior to 97 without obtaining approval of the MFP and the Council of Ministers. So if one then turns back to 326, one can make sense of what's being said and why it is wrong. Because the formality and delay that the judge refers to there, and formalities are then referred to again, are the supposed formalities of seeking consent from a governmental body. And as I say, analytically, separate point, entirely irrelevant to the BNC rules. It was nobody's evidence, nobody's case at trial, that the two-signature requirement under the BNC rules was linked or somehow depended on seeking consent from the Ministry of Finance. So
the point you make, presumably, is what degree of formality and delay was involved in Miss Marty asking or putting the name of another A signatory on the email.
Yeah. No material.
Subject to what?
Of course. Yes, and this is another reason why 326 can't be about the two-signature requirement. It's talking about something else entirely. And it reveals in my submission that, that something has gone wrong with the reasoning, and the conclusion that then follows in my submission is unsupportable. So 327, it was suggested that the fact that if BNC has an empty account with another bank and wish to close it, that still requires two signatures, even though the value of the transaction is zero, as Ms. Rodriguez accepted, affected this analysis. But this is to ignore the terms of Article 15, which specifically defined operations which require signatures, regardless of whether they are categorized for the purposes of Article 12 as banking transactions that create an obligation. And this is where the judge, we say, is right. And this is our submission, which is that one has to look at Article 15 separately. And if Section 12 or Article 12 doesn't apply, it does not follow that Article 15 also doesn't apply. And the judge recognizes the distinction in there, but it's not a distinction that's observed in the reasoning preceding this paragraph, and not one which informs the conclusion. So that's the end of the reasoning, and 328 is the conclusion. I conclude the consent to an assignment is not a banking operation within the meaning of Article 12 of the BNC rules, is not a banking operation within the meaning of Article 15L of the BNC rules. Our case is that the second element that we see there in that paragraph simply doesn't follow from the preceding reasoning. And as my Lord Justice Phillips observed when granting permission to appeal, it was arguable that the judge's conclusion was counterintuitive. We respectfully agree, and we say it was counterintuitive, because it entailed treating consent to an assignment of a long-term debt as being outside the very broad terms of Article 15L. It was contrary to the evidence of Professor Mendoza, contrary to the evidence, oral evidence of Ms. Rodriguez, and in any event we submit respectfully, it was plainly wrong. And the correct conclusion would have been that Article 15L applied to consent to an assignment, the two-signature requirement was not fulfilled, and because it was mandatory, as the judge found later on, the relevant act was not binding on BNC. And that last point, I should say, the relevant act was not binding on BNC. It's paragraph 21 of our original skeleton, which I don't understand to be in dispute.
Is it right that Dr. Mendoza, and to the extent she addressed it, Rodriguez, in addressing whether or not consent to an assignment was a banking operation, don't seem to have addressed it as a matter of Cuban law. It just seems to have been their opinion as to whether or not a banking operation, using those words, those English words, as they appear, covered a consent to assignment.
Yes.
There doesn't seem to be any legal Cuban law analysis in that.
Yes. On what? Yes. I see my Lord's point, and this is similar to the point I made earlier at the very start. That this is not a case where there's any authority, commentary, nothing. All we have is the text of the article. And that's...
Well, it goes a bit further, because it goes to what is the role of expert evidence in the first place. Because the role of expert evidence is to say what the foreign law is. It's not the role of the experts to apply the foreign law to the facts of the case. That's the judge's role. And so my Lord's question, therefore, is very pertinent. What is the Cuban law that the experts are supposed to be expounding?
I suppose the only...
It's not necessarily a point against you.
No. I see that.
Well, there's no evidence if there's no evidence as to what the Cuban law is, as to what a banking operation is, then we assume it's the same as English law.
Yes.
Do you not?
I'm not sure one can assume very much at all about... The words are what they are, and neither expert could offer any guidance. And I see my Lord's point that, is it a question of Cuban law at all? I can see the argument, and if it isn't, it's simply a question of reading the words and applying them to the facts.
Well, all that seems to have happened
yes.
is the experts have been asked, is a consent to an assignment banking operation? They've just provided their
yes.
opinion
Yes.
as on that. And as my Lord says, it's not clear why that was within the scope of their expertise.
Yes.
They don't say, well,
Yes,
looking at the following Cuban authorities or statutes or textbooks
yes.
or whatever, one can see that the scope of a banking operation is X or Y.
Yeah, and neither of them was an expert on banking.
No. I say no. I don't have their CVs to hand. I can't warrant that neither of
They
them...
were put forward not as being experts on Cuban law, not experts on banking.
Correct. Absolutely correct. But my Lord, if that is so, and the way to approach it is to say, well, properly analysed, it's not a point of Cuban law at all. It's just a question of applying the language to the facts. Well, we say that gives this court more leeway to interfere.
But you haven't actually made any submissions on why is it a banking operation?
Well, no submissions other than any other banking operation is wide enough to include this on any view, we say.
And the expert evidence that you have taken us to, I think at best, the experts, Mr. Rodriguez, when taken to it, and Professor Mendoza in his reports are, that's how I interpret 15L, and I think he goes as far as to do so in the context of the remainder of those operations which are in 15 and the nature of the other clauses. So he is, at the most, interpreting
Yes.
The words in context.
Yes.
I think that's as high as it goes as far as he's
Yes.
concerned.
And yes. And if that was not proper within the remit of the experts, then, and it was up to the judge, we say the judge's interpretation.
Well, it probably was within his remit to say it's a catch-all, but in a sense you could see that just from the words.
Yes.
It still leaves, as my Lord says, the question, well, what's a banking operation? And that seems to be, at the moment, to be a question of banking, not a question of law.
Yes.
Well, presumably say, what banks do is they borrow money and they lend money. And dealing with their borrowing and their lending are core banking operations.
Yes.
So giving consent to transfer a substantial liability from one creditor to another is a core function of the bank.
Yes, it is. And on that specific point, there is something very relevant in the judgment, which, if I may show you, my Lord. Not only is it the core business of banking, but the 13th of June email is the core business of BNC. And the reason I say this is I am going to try and find the reference on my feed. If the court can just bear with me for a second, apologies. There are two paragraphs. What? Article 7LL, the description of that, and of the 13th, how it interacts with the 13th of June email. Yes. Okay. So paragraphs 87 and 281, they need to be read with, together. 87, the judge says, this is about BNC rules. The judge says the requirements of BNC rules extend to all banking operations within their scope, including such banking operations as are conducted by BNC pursuant to its powers or functions in Article 7LL of Decree Law 181. And that's the decree law which set out the BNC's functions and powers. It was a critical piece of primary legislation. And then paragraph 281 says, thus, after quoting Professor Mendoza's evidence, thus, Article 7LL covers the 13th of June consent. So the way that the judge approached matters is to treat the 13th of June email and the consent that the judge concluded was thereby given as a matter of English law as one of the core functions of the bank within Article 7LL of the founding decree law. So really, it's a point, it's just another way of putting my lord's point, but specifically in relation to BNC.
Can I ask you this as well? The signature requirements in 15 and 17 are not just restrictive, but they're also permissive, are they not? In that the signatories to the A signatories can sign, are authorised to sign,
Yes.
other banking transactions.
Yes,
other
they're
banking
empowering.
operations.
Yeah.
And the question that seems to me arises is that if this is not a banking operation, it therefore does not fall within the signatory regime.
Yes.
And so then you then have the uncertainty of who it is who is authorised
Yes.
to consent to an
Yes.
assignment.
Yes. And I just detected a shake of the head, but my learned friends would say to that, well, you look at the BNC statutes, Articles 40 and 41, and see who is appointed to the roles to manage the Foreign Debt Office, and you work out the answer that way. But our answer to that is, that you can't circumvent the application of the BNC rules.
Yes, that is how you get in the rules. But of course, that then raises the question of, well, what if a banking operation
Yes.
doesn't fall within the rules?
Yes. Yes. But
And the respondents say to that, well, then in that case, we have the judge's finding at 320 that there was authority.
yes.
But it's odd if you have all of these different banking matters which quite clearly require signatures of A, B, whatever. Then you have what is quite a significant action, which is consenting to
Yes.
an assignment from one creditor to another, which doesn't have that
Yes.
certainty.
Yes. Absolutely. And
Entirely in your favour. I mean,
no. I with respect, adopt that. But and make the point that the Foreign Debt Office, as the name implies, this was very much the core of their job. This is what they do. Of course, it's a banking operation.
it's odd that the email doesn't actually say what her role is.
Yes. I can't remember if...
It just gives her name.
No, it doesn't. But I had got to the end of the relevant part of the judgment. So unless I can assist further, those were my submissions on ground one.
Thank you very much indeed. Where do we go from there?
My ladies, my lords, we have time to start on English law before the short adjournment. The first English law point of round 2 of BNC's appeal is ratification. And for the court's note, we address this in our skeleton argument starting at paragraph 22. Now, to locate this within the overall framework of the appeal, this point only arises if the court were to find for BNC on the Cuban law appeal ground. The learned judge found against BNC on that issue, of course, but she went on to consider the issue of ratification in case she was wrong, and she also decided that against BNC. Now, the argument here turns on BNC's responses to two letters before claim, which I'll invite the court to look at in a moment. CRF, by way of outline, argued, and the judge accepted, that if there had been, as a matter of Cuban law, unauthorized acts by BNC's employees during the assignment process. So in other words, if you were to find in BNC's favor on the matters on which Mr. Dudnikov has addressed you, in other words, there was a problem in the assignment process, then CRF argued that BNC's response to the letters before claim amounted as a matter of English law to a ratification of the acts that BNC says were unauthorized as a matter of Cuban law, and that thus those two letters cured the problem that we say, as our ground one, existed with the assignment process, cured the problem, thus making the assignments valid. So this is a backup argument by CRF in case they were wrong as a matter of Cuban law. The judge considered it, although she had found against BNC on the primary arguments of Cuban law, and she found against BNC on the backup argument of ratification, and we appeal, we sought and granted permission to appeal on that point as well.
Can you help me just one thing? Why is ratification a matter of English law?
Well, because we're now looking as a matter of, so we're looking at, in terms of choice of law, we're looking at the Cuban law questions of who as a matter of law in the relevant organization, the relevant entity, was empowered to do what, whether particular responses to letters were capable in, back in the framework of English law, it's an English law governed contract, English law question of whether, as a matter of English law, Mr. Fernandez, on behalf of BNC, had ratified the relevant putatively unauthorized acts, and the parties agreed below that that was a question. When we worked through the various choice of law issues, that was a question of English law, as indeed were the remainder of the matters that I address. So we looked at Cuban law because Cuban law governs, or the relevant foreign law, Cuban in this case, governs the internal powers and functioning of a particular entity, and this was a Cuban entity. We now look at English law being the law of the contracts when we look at
Doesn't the question of whether or not a Cuban entity has ratified the actions so as to be bound, why isn't that a matter of Cuban law?
Well, the parties certainly proceeded on the basis, as did the judge, that it was of question. Once we've looked at, if you like, the internal structure of BNC and who's empowered to do what, and of course the internal functioning of a foreign entity is a matter for that relevant law.
Ratification is a part of that, isn't it?
Well, all parties proceeded on the basis to say that,
so you say that
as a matter of English law,
I shouldn't worry about this because the parties are agreed it's English law, and that was the basis the judge determined, and nobody's appealed it.
Yeah, that was the basis on which we proceeded below. Yes. So the approach was whether one has to look at the materials and consider that whether through an English law lens, Mr. Fernandez would be seen as having ratified the unauthorized acts, whether he was a principal ratifying unauthorized acts of those within the organization.
It might be said to make our task simpler, at least to that extent.
I'm sure the court would be glad to hear more Cuban law on the point, but that was not the basis on which anybody proceeded below, whether the parties or the judge. Now, before I look at the relevant findings in the judgment, I think it might be helpful if the court would kindly turn up the relevant correspondence. There's 4 short letters, and I think it would probably help as a starting point to quickly look at those and see what was said. Now, these are in the supplementary bundle, starting at tab 10. Page 33 of the internal bundle page numbering. And we see here, this is a Gibson-Dunn letter dated the 11th of December 2019. We see that it's sent to BNC and to the Republic of Cuba. And if we go right down to the bottom under Dear Sirs, we see it describes itself as a letter before claim. And in footnote 1, and we'll come back to the relevance of the pre-action protocol, we see that it says, sent in accordance with the process set out in the practice direction on pre-action conduct and protocols. If we go over the page, it's a fairly short letter. We see that it sets out the relevant agreements. We see that it seeks payment in full under the heading Next Steps on the second page. So it's simply saying, we hold these debts and guarantees. They are owed. Next steps, please pay 71.8 million euros, inclusive of interest, in the form of a wire transfer within 14 days, and then the relevant bank details are given. So the response we see over the page, this is an English translation of a letter which was in fact written in Spanish. And we see, so this is tab 11. We see that this was sent by, we see the crest of the chairman's office of BNC, and if we flip over to the 3rd page, we see that it was signed by Mr. Fernandez, who was the chairman of the bank. We see that it was dated 30th of December 2019. Now, the first 2 paragraphs, and I'll come back when we look at the judge's findings to what she made of these, but the first 2 short paragraphs are those on which CRF relies as ratification of any unauthorized acts involved in the assignments. So we see these. I invite the court to read those 2 short paragraphs.
So we're on page?
We're on page 37.
Yes.
So this is Dear Sirs, we refer to your letter, and then the paragraph, the second paragraph in relation to this matter.
Yep.
So it's a reference to the debts in issue. And we see if the court simply skims the rest of the letter, we see that it sets out Cuba's inability to make payment, and then on the second page, bundle page 38, it sets out the difficult financial situation of the country. It mentions the intensification of the US blockade since the end of 2016, and other matters such as Hurricane Irma, and we see the reference to, in the penultimate paragraph on page 38 towards the bottom, we see the reference to $13 billion of losses. And then the letter concludes on the 3rd page. Given this situation, we ask for your understanding of these issues, which our creditors have been informed of, and who have stated they understand the complexity of the situation our country is facing. So that's the first of the 2 letters which is said to have ratified the acts which BNC says were unauthorized during the assignment process. Very quickly, to complete the picture, we have Gibson-Dunn's response in the next tab. This is 14th of January 2020. And if we turn over the page, there are some paragraphs which set out their position that there had been past attempts to negotiate. We get to the bottom line at paragraph 7. CRF will not further delay the issuance of proceedings in relation to the debts For the reasons set out above, your letter confirms that BNC and Cuba have no defence to CRF's claims to payment of the debts. Please confirm by no later than 5 o'clock London time on 28th January 2020. And then again, we have the demand for swift payment of the 71.8 million euros. And then just for the court's understanding of the chronology, this is the 14th of January 2020. CRF and Gibson Dunn were as good as their word and proceeded to issue the claim form on the 18th of February. Now, in the meantime, so before that was done, and in response to this letter, the final letter, and the second of the two letters, which is said to amount to the ratification that the court is looking at, is the next tab, so tab 13. We have the second of Mr. Fernandez's letters. This is the 27th of January. And in this letter, it's the first paragraph, just under Dear Sirs, we refer to your letter of 14th January 2020. And the court can read the remainder. It's this paragraph that we'll see when we look at the judge's findings was held to amount to a ratification. Now, in the remainder of the letter, the debate continues between the parties as to whether the debts in question were within the scope of relevant refinancing agreement with its pari passu clause, not a debate with which this court needs to concern itself, but relevant perhaps, and it will be relevant for another submission that I make later on. It is again, if we look over the page, the letter again emphasising Cuba's economic vulnerability, its inability to pay within that sort of timescale, and again in the last paragraph asking for understanding regarding Cuba's financial and economic situation described extensively in the previous letter, as we saw, with respect to which the country is making the greatest possible efforts to resolve it. So that's the chain of correspondence which is the basis for this argument in this part of the appeal. Now, a number of BNC's witnesses, including Mr. Fernandez, were cross-examined at the trial about the process that led up to the writing of those letters, so the internal process within BNC by which the responses that the court has just seen were formulated. And I'll address you shortly on the judge's findings about that. If the court takes up the judgment, this is again, this is in the core bundle at tab 8. Now, the section on ratification begins at paragraph 345 of the judgment, which in the bundle numbering is page 152. Or we can start at 343, really, which is over on 151. So if the court has that, we see that the judge firstly acknowledges the contingent nature of this argument. In other words, it only arises if, contrary to her findings on Cuban law, there had been unauthorized acts in the process. She goes on to decide it, and we see the heading at the top of 152, Ratification BNC. So she begins by setting out the legal requirements of ratification. She cites the Suncorp insurance decision at 345. Ratification may be express or implied, and will be implied whenever the conduct of the person in whose name a transaction has been entered into is such as to show that he adopts the transaction in whole or in part. Mere acquiescence or inactivity may be insufficient. Then at 346, she reproduces the requirement as set out in Bosted that the ratifying purported principal, so here Mr. Fernandez, while they need not know that the purported agent lacked authority, must still know what the purported agent has done and must have full knowledge of the material circumstances in which the act was done. And this requirement of full knowledge of the material circumstances will be of significance when I address you on the reasons why in our submission the judge erred in reaching the conclusion that we did. The point simply emphasised for now was that, as the judge correctly found, and there was very little between the parties on the law here. The judge speaks of a cigarette paper of difference. The state of knowledge of the allegedly ratifying principle, everybody agreed, was central to the analysis. At 347, the judge goes on to summarise CRF's case. If BNC's employees exceeded their authority by manifesting approval to the proposed assignments without using two signatures, their acts, this was CRF's argument, were ratified by Mr. Fernandez, who was at the relevant time the president of BNC. The judge goes on at 348 to make a number of factual findings, and I will come back to those shortly. And we'll come back to those and we'll go through them in the order that they're relevant to the various submissions that I will develop. And having made those findings, which I invite the court to skip over for now, but as I say, they will not be skipped over permanently, at 349 and 350, we see the judge's conclusions on the ratification issue, certainly as regards BNC, where she indicates it follows that with knowledge of the material circumstances and the consent of the Central Bank of Cuba, the duly authorised representative of BNC participated in the discussions in which the letters before action were considered and reviewed and signed the letters in response. So that's a reference again to Mr. Fernandez. And she says at 350, by the responses to the letters before action, in particular the second letter, BNC so conducted itself as to show that if it were the case that the assignments had not been authorised, it adopted the transactions and thus ratified the assignment of the agreements on its own behalf.
Am I right in understanding you say that's a straightforward non sequitur? It just doesn't follow from 349?
Yes, precisely. There's 4 points that we make as to why these 2 paragraphs of conclusion manifest error to the extent that this court would be justified in intervening. So we've got 4 points that arise here. Firstly, and I'll outline them and then briefly address them one by one. Firstly, the unpleaded nature of the claim that the Central Bank of Cuba had been involved in the Fernandez letters. Secondly, the judge's treatment of the factual evidence as to the extent to which BNC had reviewed underlying documentation relating to the purported assignment before replying to the letters. Thirdly, whether it was necessary for BNC to have reviewed the critical email of the 13th of June 2019 that the court has looked at with Mr. Dudnikoff before or in the process of writing the 2 letters. And fourthly, the impact of the pre-action protocol, bearing in mind that the ratification was said, and we've seen this, to be contained in BNC's responses to pre-action correspondence. I see the time.
I think that's perhaps at an appropriate moment as long as it's convenient for you.
Absolutely, of course.
Lovely. So we'll resume at 2 o'clock. Thank you very much.
Rise,